So traffic checkpoints have to be planned in advance, and the officers that are conducting these stops have to necessarily follow that plan to a T. For instance, it has to start at 8 o'clock and it has to end directly at 10 p.m. Are they going to check every vehicle, or is it going to be every third vehicle? Otherwise, it's an unconstitutional stop if they don't follow that plan.
If you see a DUI stop ahead of you, is it legal to turn off, make a U-turn, purposely avoid it?
Right. So Virginia actually had a case directly on point with that, and the case basically said that in the event that you attempt to evade the traffic checkpoint, that in and of itself creates reasonable suspicion of criminal activity. Obviously, it depended upon how far back you are from the checkpoint. You know, if you're simply making a right-hand turn into another lane, but if they see you approaching and you effectuate a U-turn, and then they send out a police chase car after you, then certainly the officer has reasonable suspicion to believe that something is afoot.
Are you allowed to drive in the grass 100 miles an hour past the checkpoint?
No. You're not allowed to drive in the grass 100 miles per hour past the checkpoint.
What about when you pull up to the checkpoint and you don't want to roll your window down or don't want to roll your window all the way down?
Right.
Is that a problem?
Obviously, you know, there's a Fifth Amendment at play here, which is that you do not have to provide what otherwise may be incriminating evidence against yourself. You have the right to refuse to comply with things such as field sobriety tests, but you don't have the right to refuse your identity or to provide information that is otherwise readily available to you, such as your driver's registration and those types of things. I've handled cases where a driver will appear nervous, and the officer will say, you know, I stopped him and he appeared nervous, so I pulled him over in order to do a further investigation. And the case law is very clear. That case law says that you cannot exceed the scope of what is otherwise necessary to effectuate giving a summons if the individual committed some type of offense beyond what is necessary to actually give them the summons. So if you're driving through and you've got drugs in the trunk and you appear nervous and I'm going to write you a summons because you have a defective headlight, I can't pull you over for 30 minutes, call drug dogs to the car, have them circle the vehicle, and then have them alert, because the nature of that stop was only to give you a summons, right, for the headlight, which would normally take 5 to 6 minutes, and yet I've stopped you for 30 without really any type of reasonable suspicion beyond just the headlight itself. Nervousness in and of itself isn't going to get you there. Now, nervousness plus an odor of marijuana, you know, the odor of marijuana or the odor of other drugs certainly gives rise to them being able to search you even without your consent. So in that circumstance, if you refuse consent and they get drug dogs on the scene, then that, I think, would probably constitute reasonable suspicion to exceed the scope of the initial stop.